Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, this has been quite a momentous couple of weeks, haven't it? From New York Pistol and Rifle Association v. Bruen and all the fallout that comes with that. And really, we've already tried to dissect this case and talk about, hey, what does this really mean to us? We've done a video on that already. But I want to spend a little bit more time today talking about some of the fallout that is really becoming evident now from this case and the impact that it may have on for you in the lawful and responsible gun owning community. So I think we're going to need to spend a few minutes today talking about, are the legal dominoes starting to fall on gun control? Okay, so the issue that we're talking about today is the fallout from New York Pistol and Rifle Association v. Bruen. And I think that we'll probably end up doing more videos on this as time goes by, because I don't think that we really truly have grasped the potential impact of this case. But there are some very immediate things that have happened. So let's get you up to date on what has this case done for you, the lawful and responsible gun owner nationwide. Well, first of all, as we know, there were 4 cases that were pending certiorari before the United States Supreme Court, which is a fancy way of saying they were on the waiting list to see if they were going to get an invite to actually get to be argued in front of the Supreme Court or get rejected and be sent down to the lower court. Now, there were 4 cases, and they really dominate 3 issues here. Okay, so there's Duncan v. Bonte, which is the California magazine ban. There's the New Jersey Pistol and Rifle Association v. Bruck. That is New Jersey's magazine ban. So we have 2 cases related to magazine bans, one coming out of the 9th Circuit, the other one coming out of New Jersey, which is either the 4th or 2nd Circuit, okay? Those were being awaiting certiorari. Then we had Bianchi v. Frosch. That is a case challenging Maryland's assault rifle ban. And then finally, we had a case of Young v. Hawaii, which dealt with Hawaii's rather oppressive concealed carry laws, which aren't that much different than New York's, which were just struck down. Now, we know in each and every one of these 4 cases, the Supreme Court GVR'd them. What does GVR mean? Well, we already did a video on that, so you can geek out on that a little bit more detail there. But essentially what it means is that they granted the review, they vacated the ruling of the lower court, and they remanded it for further findings consistent with what the Supreme Court has announced is the rule of law to determine the constitutionality of gun control regulations. So obviously, the GVR on all 4 of these cases bodes very well for the Second Amendment community, because essentially the Supreme Court is telling these lower circuit courts, hey, listen, we're going to give you another chance to fix this problem, and if you don't fix it, we'll fix it for you. Now, on the Duncan v. Bonte case, here's another update. That didn't stop our good friends over at the Firearms Policy Coalition for filing a motion to lift stay. Now, if you go back and you look at the procedural history of Duncan v. Bonte, Duncan won at the trial court level. Judge Benitez issued an injunction against California's magazine ban. Now, and then, of course, a 3-judge panel in the 9th Circuit also upheld that ban. It wasn't until an en banc panel of the entire 9th Circuit was the law upheld. So there originally was a stay of that law issued by Judge Benitez. Of course, that stay was then lifted when the 9th Circuit said, this is good law. The Firearms Policy Coalition has basically filed a motion with the 9th Circuit saying, listen, no reasonable person can read what's going on here and think that the ruling of the 9th Circuit has to be contrary to what you previously ruled. The Supreme Court has told you in Bruen what the rule of law is. The Supreme Court has told you the answer you should come up with. And if you apply the rule clearly announced by the Supreme Court, you're going to come to a different decision. This magazine ban is going to be deemed unconstitutional, and therefore you need to lift the stay right now. So we'll keep you posted about this, but hey, for those of you in California, and I know I do have a lot of California subscribers, thank you very much. Washington State rapidly tries to catch up with you guys on a daily basis when it comes to crazy gun laws, but you may have another Freedom Week coming. You may have something much more than that, which is actual freedom. Okay, now another update, another fallout from Bruen, this one in the state of Maryland. That's right. Maryland had one of these rather oppressive concealed carry laws. In fact, in Maryland, not only did you need to establish that you were otherwise lawfully allowed to possess a firearm, you also needed to have good and substantial cause in order to show that you really, really needed the ability to actually defend yourself. That is essentially a may-issue state. May-issue states have all been put on notice by the ruling of Bruen that essentially that law is unconstitutional. And how each of these individual states are reacting to it is very interesting. I got to applaud Governor Hogan here in the state of Maryland, because today Governor Hogan instructed the Maryland State Police to remove the good and substantial reason from the application process. In fact, Governor Hogan was quoted as stating the following: "In light of the ruling and to ensure compliance with the Constitution, I am directing the Maryland State Police to immediately suspend utilization of the good and substantial reason standard when reviewing all applications for wear and carry permits." Governor Hogan also stated it would be unconstitutional to continue enforcing this provision in state law. So congratulations to Governor Hogan for doing the right thing. Congratulations to the residents of the state of Maryland for getting some of your constitutional rights and freedoms back. But not everyone is being as good a sport as Governor Hogan in Maryland. Take, for example, the state of California, Governor Gavin Newsom and Rob Bonte, the Attorney General. You see, they're having none of this Supreme Court nonsense. They are still looking for new and creative ways in which they can ensure that the citizens of California do not enjoy their Second Amendment rights. Almost immediately after the opinion came down in Bruen from the United States Supreme Court, Rob Bonte had his talking points ready about how it really didn't necessarily apply to California. Well, California has had a rethinking of that position, and they do realize that Bruen applies, but don't worry, they have new and creative ways to continue to disarm their citizens. The Attorney General himself, in his talking points, in the press release that he issued right after the Bruen case was decided, states the following: "In accordance with Bruen, the Attorney General now considers the good cause requirements set forth in California Penal Code sections 26150 and 26155 to be unconstitutional and unenforceable. The immediate implications for law enforcement agencies that issue publishing and carrying permits are as follows." And then Attorney General Bonte goes through a laundry list of reasons why they cannot use that as a clause to determine the person's eligibility to possess a firearm. So, problem solved, right? Okay, Californians, you guys are now a shall issue state. No, not so fast, you see, because your Attorney General and your governor still want to point out that, you also need to have good moral character. And what exactly does that mean? Well, in California, that's an interesting question. And as you can see from what the Attorney General is saying here, they want to greatly expand this role. Accordingly, in assessing whether an applicant has established good moral character, issuing authorities should recognize that Bruen does not eliminate the duty or authority of local officials to protect the communities that they know best by ensuring that licenses are only issued to individuals by virtue of their character and temperament can be trusted to abide by the law and otherwise ensure the safety of themselves and others. And they also state, good moral character is the distinct question that requires an independent determination. And in this memo, Rob Bonte is talking about, hey, this goes way beyond just determining whether or not they are eligible to possess a firearm. Now, what is good moral character in the state of California? I don't know. Does the governor get to decide this? Is this the same governor who issues rules but then doesn't follow those rules? I don't know. I digress. Now, in addition to that, California is announcing a whole new slew of areas in which they are going to prohibit the carry of firearms. Now, the areas that they're currently describing are areas that are pretty consistent with what we enjoy here or what we experience here in Washington State. Schools, secured areas of airports, correctional facilities, courthouses, and things like that. Do not be shocked, however, if Attorney General Bonte and Governor Newsom come up with a laundry list of areas so that the only place you may be allowed to carry a firearm in the state of California will be somewhere in the middle of the Mojave Desert. And then finally, and this is another fallout here, and this is important, and we're going to have to keep you posted. We're going to do a separate video on this later on this week. Torsivia v. Suffolk County, New York. Now, what is this? This is a petition for a writ of certiorari. This is asking the Supreme Court to review this issue. What happens in this? Torsivia is contacted by law enforcement for various reasons. Torcivia is acting rather unruly, mentally unstable. They're concerned about violence and things like that. They take him to the hospital for a mental health assessment. Law enforcement learns that Torcivia has firearms and goes back to his home and immediately seizes all the firearms. Now, at the time that Torcivia is being treated in the mental health institution, he has not been charged with a crime. He has not been issued a red flag order. He does not have a protection order on him. He is under the jurisdiction of no court at the time. The law enforcement in New York justifies this search through what's called the special needs exception, which is we had such special needs that screw the Fourth Amendment, we get to go in and take the guns. This is now being challenged by Torcivia's attorney, and I've had an opportunity to read the petition for certiorari, and listen, this thing has some teeth, okay? And this goes far beyond the Second Amendment. This has a lot to do with Fourth Amendment search and seizure issues. Why is this important, okay? Here's why it's important, because when we're talking about red flag laws, and we know now there's a push for national red flag laws, and we've done a video on that. When we start talking about how do red flag laws typically, how does enforcement begin? Well, a petitioner goes, gets a temporary order, the order is issued, law enforcement then shows up at the house with just the order and immediately goes and seizes all the firearms. If that activity is found to be unconstitutional in certain settings, it could literally take the teeth away from the way red flag laws are enforced, which is one of the constitutional issues that I have foreseen with these laws for a number of years now. So the bottom line is this. The fallout from Bruen has just begun. The dominoes are beginning to fall. There will clearly be much more fallout as we see how many other courts adopt the very clear rule of law announced by the Supreme Court, and how many governors, predominantly those in bluer states, look for creative ways to ignore the ruling of the highest court in the land. In the meantime, some of you may have questions about this or anything else related to your Second Amendment rights, and if you do, don't ever hesitate to contact us at WashingtonGunLaw.com. Or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we preach all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.